Hi everyone, this is Shauna Tarosa, RAYAC Executive Officer, and this is my desk. In this monthly video cast, I go over questions that are coming across my desk every single day so we can have much smoother real estate transactions here in York and Adams counties. And the topic that I have today is mediations are up. Yes, we are recording this video in August of 2026, and the mediations here at RAYAC are up 38% over the same time period last year. So what is driving those mediations, and what can you do to help your clients avoid landing a mediation themselves? And if they do need to do mediation, what are some tips and tricks moving it forward? So overwhelmingly, the number one issue driving up the mediations is seller property disclosure issues. And are there any particular seller property disclosure issues that we're seeing? Well, they're really all across the board. A couple of years ago, we would have said absolutely the number one issue we see is water in the basement is what causes clients to go into mediation because it was never disclosed to them that there's water in the basement. That still continues to be there, but there's a whole host of other issues, things not working, problems with the septic system, all sorts of things that are allegedly not being disclosed to the buyers when they are purchasing the property. So what can you tell your sellers to do to help avoid getting into mediation later? Well, the best answer is disclose, disclose, disclose. So too often what we are seeing on the seller's property disclosure statements is so many of the questions are being left blank, just unanswered, not being addressed at all during the seller's property disclosure statement. So in order to avoid a disclosure issue in the future is you need to disclose it up front. So I would encourage you to tell your clients as the sellers to please go through and fill out that seller's property disclosure statement completely and don't leave things blank, because the more completely you fill it out, the more information you're putting out there to the potential buyers, the more you're going to protect yourself in the future from landing into a mediation case. The other issue that we are seeing very frequently is many times when the buyers are filing for the mediation is they don't have any contact information for the seller. And we need that contact information. If we're not able to send the appropriate paperwork to the seller over the mediation process, then we're not going to get a response from them, and you're only going to be left to go through the litigation process, which can be much more costly and timely if you're looking to resolve an issue. So in the agreement of sale, there is a mailing section. That section should never be left blank for both the buyer and the seller. You should always be filling out that information so that you have it in the unfortunate circumstances if you need to file a mediation here at the association as well. The other big question that we get is how long do they have to file for mediation? Well, we do not have a time frame associated with the mediation process here at RAYAC. Anybody can choose to file a mediation at any time. However, in Pennsylvania, there is a statute on the seller's property disclosure law that says you cannot litigate seller property disclosure issues after 2 years from purchasing of the property. So what we normally advise, and we have seen that a lot this year, where buyers are waiting to file mediation until they're close to that 2-year mark. So when that happens, if the buyer is potentially close to that 2-year mark from the purchasing of the property, in order to retain their rights to also pursue the matter in the Commonwealth court system, if mediation is unsuccessful, we tell them to file both mediation and litigation simultaneously. So according to your PAR agreement of sale, if that's what you're using to purchase a property, there is a clause in there that says that you're going to mediate before you litigate. So if you file them simultaneously, most likely mediation will take place beforehand anyway, because our process is a lot faster than going through the court system. But by filing your lawsuit at the same time, you've maintained your right to sue within that 2-year time frame of purchasing the property. And we do believe that there is a very great product out there known as Seller Shield, where you can provide that for free to your clients, and it is an online platform where the clients will be able to fill out the seller's property disclosure statement. And if there are ever any questions over what any of those sections of the seller's property disclosure statement means if they're using Seller Shield, there are pop-up blocks that they can click on to get more information to say what would be an example that something I might want to disclose here. And the beauty of the Seller Shield product is it forces the client to answer every single question, even if the answer is unknown. And that's perfectly fine, because if it's unknown, it's unknown. But it makes them fill out completely the seller's property disclosure statement, so we ensure that nothing is left blank. Because if we're answering all of the questions, we're putting as much information out there as possible, the likelihood of going to mediation will decrease, and the sellers won't land themselves in these issues after the property has been purchased. So I hope that information was helpful to you. If there's ever any questions over other topics that you would like for me to address during this video series, please feel free to reach out to me because my doors and ears are always open to you. Thanks so much and have a wonderful day.